Hi, my name is Leah Hewling, and I am presenting on guardianship and conservatorship in the mental health field. Beginning with defining these two terms, according to Massachusetts law, a guardian is a person who looks after someone who does not have the capacity to take care of themselves in terms of medical care or residency, while a conservator is a person who looks after said individual's finances or assets and property. It's important to keep in mind that each state differs in their legal definition of capacity, but all are based on the same premise that adults can perform any lawful task of their choosing until found to lack legal capacity by a judge. So, why is this important to psychologists? According to the National Center for State Courts, there are approximately 1.3 million adults under guardianship in the US in 2021, as well as 1.5 million adults under conservatorship in the US in 2021 as well. This population can also include individuals who have been appointed guardians related to age, mental health, and physical disability. As I mentioned previously, the definition of capacity. That being said, I focus mainly on the Massachusetts law, although I did gather that most definitions are based off of the idea in guardianship determinations, the decision ultimately centers around capacity, and that is the ability of an individual to meet personal needs of safety, health, and well being. Capacity is not static and it fluctuates, which is really important to note. Guardianship and conservatorship is not permanent, and the amount of guardianship and conservatorship can fluctuate as well. But most states measure diminished capacity by a presence of disabling condition, functional impairment, and impaired cognitive functioning, with some states adding in a fourth aspect. That is, the guardianship is necessary and it's the least restrictive option of care. And again, this is focused on a spectrum of capacity. So no capacity to care for oneself would be an incapacitated person, which is defined as one who cannot receive and evaluate information or make or communicate decisions to such an extent that the individual lacks the ability to meet essential requirements for physical health, safety, self-care, even with the appropriate technology assistance. So basing off of how the psychologist can deem capacity, as well as the court determines guardianship and conservatorship. Since we're talking about capacity and just kind of how that fluctuates, and I mentioned on the other end of the spectrum of it is an incapacitated person. As far as guardianship being appointed to an individual deemed incapacitated is for reasons other than advanced age or minority. It could be a clinical diagnosed condition or really any condition that results in the inability to receive and evaluate information, communicate decisions, and lack the ability to meet essential requirements for physical health, safety, and self-care, even with appropriate technological assistance. In the same light, a conservator would be appointed to an incapacitated individual if the person is unable to manage property and business affairs. So it's more of that financial piece for the same impairments or inabilities to meet their requirements for things like paying bills, anything physical, medical treatment, psychological treatment, anything having to do with the finances of that individual. When working with minors who have been appointed either a guardian or a conservator, important to know the reasons why they could be appointed this relationship. So the court appoints a guardian of a minor if the minor's parents are deceased or incapacitated, if the parents give consent, or the parents' parental rights have been terminated, or if they have signed a voluntary surrender, as well as if the court finds the parents jointly or the surviving parent to be unavailable or unfit to have custody. Conservator of a minor is appointed again by the court if The child has a estate or affairs that need to be managed, or the child is at risk of funds needed for education to be mismanaged. Um, and lastly, the parental appointment of a guardian occurs, um, again with a parent's death or an incapacitated, unfit parent, as well as a examining physician deeming a parent not able to care for a child. So just as capacity fluctuates with individuals in need of guardianship or conservatorship, the amount of care and the amount of responsibility a guardian has can range from limited to temporary to full guardianship. Here we see, beginning with the lowest amount in limited, is individuals may be competent for one purpose and not competent for another. For example, guardianship may be limited or only applied to medical treatment decisions. So a lot of times we see this with older individuals in the elderly community, having a guardian to make sure they're caring for their medical conditions or treatments. And next, there's temporary guardianship, which is usually while there's a petition for an appointed guardian is pending. The court will find an emergency guardian, and it may be for a period of 90 days unless longer is needed in extreme cases. And at the top, we have full guardianship, which removes all personal decision-making responsibility and authority. And that's up to clinicians in the court to preserve an incapacitated person's legal rights in specific areas, whether that's mental health or medical treatment or anything of the sort. Similarly, with conservatorship, we have the same sort of range from limited, temporary to full care. And for limited here, we see that it might only apply to investments or real estate and leave the protected person the ability to receive pension income and pay for daily and monthly expenses. It might also be the case that a conservatorship is not necessary, but it's narrowly tailored a protective order, and it will suffice to protect an individual's assets or property. And as an example, the court authorizes any contract, trust, or transaction in best interest of the protected person with the limited conservatorship. Moving to the temporary conservatorship, again, this is usually while there's a petition for appointment of a conservator that is pending, and the person needing to be protected is in an immediate need, and the court will appoint someone in the meantime. And again, this period is up to 90 days, and then it's reevaluated. For full conservatorship, this removes a person from the ability to control all assets, and the court must now consider if a conservatorship can be limited, which means the court can preserve legal rights in any specific areas of the individual in need, but this also does mean they have no financial autonomy, and they cannot access or make any transactions of their funds without the conservator. In terms of mental health care, we use the terms guardianship and conservatorship for individuals in the mental health and legal system that are not equipped to care for themselves due to mental illness or disability. A lot of times we see cognitive impairment in the elderly population. And in the mental health field, guardianship and conservatorship should be used as a last resort and only if other alternatives are unavailable or ineffective. Again, primarily you see guardianship and conservatorship with minors and elderly people, but there's also people who are suffering from severe cognitive impairment and other mental illness that are not capable of caring for themselves daily. Sort of shifting focus here toward the psychologist-specific role, appointed guardianship and conservatorship, kind of breaking down the process of how an individual is appointed a guardian or conservator. We have psychological evaluations and assessments that are required of the psychologist and often referred to by the court. And the assessments essentially help the court determine whether the individual is suitable for the role of a guardian or conservator, as well as if the individual is in need of a guardian or conservator. Beginning with evaluations, these are different from court investigator reports. It's a clinical evaluation of the person's capacity to problem solve, make decisions. It's performed by a psychologist or a psychiatrist and also a licensed social worker. There's several components which aim to review mental and medical health history, interview with the individual, family, and friends, and perform psychological testing. The purpose is to assess the individual's cognitive functioning, emotional stability, and capacity to make decisions. And here, in these evaluations, the psychologists might discover any behavioral health issues that might limit the guardian's ability to provide care. Moving on to the psychological assessments, these are designed to help the court determine the individual and guardian's capacity to decision make and the mental health status of both. So this process includes clinical evaluation, which is clinical interviews and written reports, mental status examination, neuropsychological testing, and personality assessment. So to kind of dive in deeper on these assessments, starting with the clinical interview, it's typically the first step in the assessment process, and the individual being assessed will meet with a mental health professional, like the psychologist, psychiatrist, who will ask questions about their mental health history, current symptoms, and their ability to make decisions. Next, the mental status examination is a brief assessment of the individual's current mental state, and this may involve assessing their mood, affect, thought processes, and level of cognitive functioning. For neuropsychological testing, this is used to assess the individual's cognitive functioning, like memory, attention, problem-solving skills, and it can help, again, determine their capacity to make decisions and provide appropriate care for themselves, or if it's the guardian, provide appropriate care for the person they would be appointed to care for. Next, we have personality assessments, which are used to identify any personality traits or disorders that may affect the individual's ability to care for themselves or the ability to care for the individual. It can also help determine whether the individual is suitable for the role of guardian or conservator. So using evaluation and assessment, whether that's through interviews, collecting information that way from family members and friends, or written reports, which mental health professionals provide, the psychologist will begin a recommendation to the court of their findings. With the psychologist's role, a crucial piece to the psychologist's responsibilities is advocating for the individual being appointed a guardian or conservator, meaning understanding values and culture is extremely important in working with a vulnerable individual, as well as making sure everybody involved is constantly upholding their rights, their wants, their wishes. So unfortunately, we see that many members of the LGBTQIA community face greater risk, as well as any structural gaps and blind spots in the system that appoints guardianship to an individual. We know that culture and values heavily impact choice and decision making. So keeping things in mind like race, ethnicity, religion, and socioeconomic status, this all needs to be considered when appointing a guardian and conservator, and making sure that the individual's needs are being met according to their values, their culture, their beliefs. Again, balancing risks with alternatives, the least restrictive level of guardianship possible and appropriate for the individual should always be the primary goal for the ethical practice of guardianship evaluations. Um, Level of risk varies greatly depending on social and environmental supports, and functional status alone does not lead to a decision of capacity. So it's spoken of the interactive component, which essentially illustrates the relationship between an individual's capacity and their environment. As an example of this, there could be two different individuals who are suffering the same cognitive impairments of memory loss, but one individual lives with family who has social support systems helping them make decisions, and the other individual might live alone or just with a spouse with no help on the day to day. So, although these two individuals have the same functional status, that does not necessarily mean their capacity is the same. So, keeping in mind all of these things when working with an individual in guardianship or conservatorship, and making sure we're always looking towards alternatives. Some alternatives to guardianship and conservatorship could be in-home care or increasing visits from family, friends, and neighbors, providing emergency alert systems, or other technological tools that could help this individual. As far as financial concerns for a conservator, there's definitely all sorts of assistance that can help an individual who is not at capacity to make financial decisions about paying bills, managing assets, and other things such as being taken advantage of financially, such as scams, things like that. So maintaining not only the individual's values and culture, but also taking into consideration their environment and their, whether that's physical or socially. Again, there are many things that a psychologist should consider when working with the guardian or conservator. So, as far as evaluation, states vary in their order for determining guardians, but courts uphold the right to exercise judicial discretion to determine what is best for the individual. So, a psychologist is often called upon to recommend who may be best suited to be the guardian of said individual. One thing to be weary of as a psychologist working with a guardian is undue influence, and this is the use of power by a party deceptively substituting the individual's wishes for those of their own. Awareness of the risk factors for undue influence as well in change in behavioral patterns regarding money, estate issues, or caregiving patterns should be present in every guardian evaluation process. Dudley and Edmonds, 2018, outlined red flags for undue influence by 4 risk factors, these being relationship, social or environmental, psychological and physical, and legal risks. Undue influence occurs when the individual invests trust and confidence in the guardian, and there's relative isolation where their vulnerability is being taken advantage of, and they're easily influenced due to their mental capacity in different circumstances. So this should be something that should always be in the forefront of an evaluation with a guardian. Specific ethical codes and standards psychologists uphold. Again, psychologists should ensure the rights of their clients are protected, even if those rights are delegated to a guardian or conservator. Maintaining clients' dignity and respect by being an advocate for the client is also really important for the psychologist. Communicating with the guardian or conservator a clear understanding of their role and responsibility, as well as necessary education and information about the client's condition and treatment, is also essential, again, to just make sure the best interest of the client is our goal in working with guardians and conservators, as well as referring recommendations to the court. There are various ethical implications when working with individuals with guardians and conservators, but also with the guardians and conservators as well. Beginning with informed consent, psychologists must obtain informed consent from the client whenever possible, even if the client has a guardian or conservator. So, informed consent means that the client understands the purpose and potential risks of treatment, as well as their right to refuse or terminate treatment. Um, and if the client is unable to provide informed consent, the psychologist should obtain consent from the guardian or conservator, um, while still keeping the client's best interests in mind. Next, confidentiality. The psychologist must maintain the client's information and including information shared with the guardian and conservator. So they should only disclose confidential information with the client's permission or as required by law. So if a guardian or conservator requests information, the psychologist should only disclose information that's necessary for the guardian or conservator to carry out their responsibilities. This also goes into competence, and psychologists must provide services that are always within their area of competence and training. So if a psychologist is not competent in a particular service, they should refer the client to a professional who is competent to work with guardians and conservators. Another concern would be respect for people's rights and dignity. Psychologists must respect the dignity and worth of all people and their right to privacy, confidentiality, and self-determination. And this includes the clients who have a guardian or a conservator. They should strive to ensure that the clients are protected even if those rights have been delegated to a guardian or conservator. Lastly, collaborative relationships. Psychologists should work collaboratively with guardians or conservators to ensure that the client receives appropriate care. This includes communicating with the guardian or conservator to ensure that they have a clear understanding of their role and responsibilities, as well as to provide any necessary information about the client's condition and treatment. So again, this collaborative relationship will be affected and impacted by ethical implications of psychologists. Working with an individual with a guardian or really important to be aware of the specific ethics and codes and standards. So I provided a somewhat summarization of the most important ethics codes that can apply to this scenario, beginning with 2.01, Boundaries of Competence, which explains that psychologists provide services, teach, and conduct research with populations and in areas only within the boundaries of their competence based on education, training, supervised experience, consultation, and professional experience, as well as psychologists planning to provide services must undertake relevant education and training. For 3.10, Informed Consent says and focuses on, for persons incapable of giving consent, psychologists explain, seek assent, consider best interests, obtain legal permission, and protect the individual. When psychological services are court-ordered, psychologists inform individual of the nature of the anticipated services. For 9.3, Informed Consent and Assessment, I highlighted that psychologists obtain informed consent for assessments, evaluations, or diagnostic services, as well as psychologists inform persons with questionable capacity to consent. 10.1 emphasizes that psychologists inform clients as early as feasible in the therapeutic relationship about anticipated course of therapy, fees, third party, and limits of confidentiality. I saw this one was important to include just because I imagine that working in a collaborative relationship with a guardian and the individual is a tricky ethical standpoint for a psychologist. So being aware that that needs to be informed to the client immediately is really important. And lastly, for 4.1, confidentiality, psychologists have primary obligation to take responsible precautions to protect confidential information obtained through or stored in any medium, recognizing that the extent and limits of confidentiality may be regulated by law, institutional rules, or a professional relationship. So just maintaining that confidentiality is really important, especially when working in an unusual relationship of somebody advocating for the rights of another person. So these are the specific codes I would see fit for this scenario. The biggest ethical dilemma for a psychologist working with a client who has a guardian or conservator, in my opinion, would be the challenge of balancing the client's autonomy and self-determination based on the legal authority and responsibility of the guardian and conservator. APA Ethics Code explains that psychologists must respect the client's right to autonomy and right to make decisions about their own life. However, when a client has a legally assigned person to make their decisions, I can really see how this could be complex. So it brings upon the question how to treat a client whose wants and needs are determined by another individual. And I would assume that knowing your responsibility as a provider, basically your competency, is really important, and to aim to help the client and guardian and conservator resolve any problems, create a collaborative relationship with all individuals involved, respect the decision of the guardian and conservator, and know how and when to report suspected misconduct and maltreatment. Regularly consult with other psychological and legal professionals throughout your time working with guardianship and conservatorship. To help explain and kind of paint the picture of the psychologist, guardianship and conservatorship, and maybe a common case example, I use an example from Dudley and Edmonds' Psychology's Role in Guardianship and Conservatorship Evaluations, which provided the case example of Grace Tuthill. And the overview of the client would be she has a history of a stroke and she was referred by the courts for evaluation following a petition of guardianship filed by her daughter Charlotte. Charlotte Tuthill reported concern for her mother's declining cognitive status as she was losing memory, not paying bills, and giving away large sums of money to charities she had not previously donated to. She wanted to provide full care to her mother and take charge of her financial accounts so her mother was not taken advantage of. Moving forward, to explain the psychologist's role here, prior to the evaluation, Grace is given notification of the evaluation, the reason for the evaluation, and possible consequences. So in this case, the client would be made aware that a possible guardianship was being petitioned, and that could be the outcome of the exam and evaluation. So Grace felt that she was able to manage her finances on her own and did not need her daughter Charlotte to become her full guardian. During evaluation, the psychologist asked Grace to name her physician, identify her source of income, all what she could not do. So simple questions that an individual who has the capacity to make decisions for themselves should be able to answer. So the next step is to perform cognitive testing, which revealed, in Grace's case, impaired performance across attention, memory, language functions, visual spatial skills, speed of information processing, reasoning, and executive functions. So now the psychologist makes a recommendation using clinical judgment. So as a result, in Grace's neuropsychological testing, it was determined that Grace Tuthill was unable to understand her current financial status and could not demonstrate reasoned decision-making regarding her medical treatment. Her impaired cognitive functioning confirmed that she'll be unable to learn and retain information she needs. It suggested that Grace Tuthill is appointed a full permanent guardianship rather than limited guardianship. So again, seeing that the court did not request of the psychologist to input opinion on who the guardian should be, the psychologist will not include that it should or should not be Charlotte in this case. So that just kind of gives you an idea of how a psychologist might work in conjunction with the court to determine guardianship. So another aspect to the ethical and legal concerns of guardianship and conservatorship, as well as the psychologist's ethical concerns, would be guardianship and conservatorship abuse. So we commonly see financial abuse with the elderly population. This is because it's a position of power over vulnerable people, whether they're cognitively impaired or physically impaired. So perpetrators of guardianship fraud can be anyone from attorneys, family members, caregivers, and others close to the individual. The psychologist plays a role in the guardian evaluation, as we previously discussed. So they're kind of responsible for identifying any red flags that this may be the case. One of the most well-known conservatorship cases is the Britney Spears case, the Free Britney. A lot of people recognize it as. In her case, Jamie Spears, her father, became her legal conservator in 2008 along with her attorney. So there are two co-conservators. This was following a psychiatric hospitalization and a time that was publicly known as a mental breakdown for Britney. Her conservators were accused of abusing their financial power, restricting her access to large amounts of money that she made over her career, and she publicly made an announcement why she wanted out and that her life was being unfairly controlled by her father and her attorney. This case is really interesting because we can kind of see the power of media and her fan base, and I think it brought a lot of awareness and attention to not only mental health, but guardianship and conservatorship. So that's down here where we see the picture of her fans protesting. It was a really huge deal for conservatorship abuse awareness. I included this clip of how Britney's conservatorship comes to an end. I think it does a really great job of showcasing not only her story, but the dangers of conservatorship and guardianship abuse. Britney advocates for herself in that her mental health and a time of vulnerability was taken advantage of, and that she was unable to legally make her own decisions in the way that affected her life. I thought it was pretty interesting as well, the polarization on the topic. A lot of people are split because there is proof that the conservatorship did help Britney get out of debt and maintain her finances, but then on the opposite side of that, her fans were enraged for the control and afraid for her life. So going off of Britney Spears' conservatorship case, it's important to note that National Guardianship and Conservatorship Abuse and Awareness Day is actually February 1st, and it's an effort to maintain awareness of guardian and conservator abuse, as well as educate and advocate to protect rights and dignity of individuals in care. So in order to observe this day, it's recommended to attend a virtual conference that is held every year, which I included the link to, as well as post about it and educate yourself and others. I think that big cases like Britney Spears emphasizes the need for advocacy, but it's important to continue to educate yourself on the topic. Despite the last few examples, there are positives to guardianship and conservatorship, and the biggest being that they protect individuals from those set on taking advantage of them. So ultimately, it creates a system of safety for vulnerable individuals. They access confidential information, communicate with medical and mental health providers, hire services to benefit the individual, encourage compliance with mental health and medical treatment, marshal assets and protect spending, pay bills, manage contracts, accounts, and retain counsel. So, for individuals in need of this, there are many positive attributes to guardianship and conservatorship. In mental health terms, it's also a really important piece for individuals who might not be able to make mental health treatment decisions on their own. It's crucial to have somebody advocating for their needs and their wants and their wishes, and oftentimes it's very beneficial. So in summary, this presentation was meant to highlight the difference between guardianship and conservatorship, explain the psychologist's role and the mental health role, as well as ethical standards and concerns that a psychologist might need in this scenario. So thank you. And here are my references.